deposition, and when you feel like the facts are hazy or maybe you're not sure of the answer, people have a tendency to equivocate, to remember things the way they would like them to be, and give an answer that's not entirely factual. And so it's important that you examine what you know and what you don't know before a deposition. And oftentimes what you don't know is more important than what you do know. So if you go into a deposition and have a firm understanding of what you recall, what you know, and what you don't know, you'll do a better job about telling the truth in the deposition than if you haven't really thought about all those things or crystallized those areas in which your knowledge is not very good, or in which you have no knowledge. Keep in mind that a perfectly acceptable answer, if it's true, to certain questions is, I don't know. And if that indeed is your answer, and you're saying it very frequently, then don't feel like you're doing anything wrong. Oftentimes, questioners will try to ask a series of questions to a witness that elicit a response of, I don't know. And after the witness says, I don't know, 1 or 2 or 3 or 4 or 5 times, the witness feels like, wow, I must be a dummy. I need to come up with some facts here quick. That's not the case. Very often, people involved in lawsuits labor under the misapprehension that they need to have all of the facts within their knowledge, and they need to testify about everything that's going to get them a victory in their case. That's simply not true. Oftentimes, the evidence that we put on a trial is a patchwork of different people's testimony, of documentary evidence, and of knowledge derived from different sources. So just because there are areas about which are germane to your case that you're asked that you don't know the answer to, you're not to feel bad, or you're not to feel like you should come up with some answers. You need to testify to the truth as to what you know, and the truth as to what you don't know. Now, giving a deposition, you realize, could be a long and involved procedure, and to the extent that you need to take any breaks, it's perfectly fine and acceptable to do so. Also, to the extent that you need to consult with counsel, that's appropriate as long as there's no question pending. To the extent that you recall something and you know the information, very oftentimes it happens that when you're asked a question, the answer I should say, is on the tip of your tongue and you can't seem to get it out. If you do recall later in the deposition the answer to a question asked previously, it's perfectly fine to stop and say, you know what, let's go back to a question you asked me 10 minutes ago. I now remember the answer. And it's quite frequent that you'll find that as you start to relive events and as you're asked different questions and as the questioning proceeds with names and places and documents, you may find that your recollection is prompted. And so don't hesitate to go back in that fashion to correct the record and make sure the record and testimony you're giving is as accurate as possible. The reason for that is that, as I said, your testimony is locked in, so to speak, in a deposition. And so very often a questioner will try to get you to recall everything about a specific event. Keep in mind, if you're asked, let's say, for example, about your damages, and you say, well, I was damaged, and you tick off A, B, C, D, E elements of damage. And later you get on the stand at trial and you testify, well, I was damaged A, B, C, D, E, F, and G. You can be sure that that deposition is going to come out, and the attorney is going to say, well, you remember when I deposed you at a time more closely in time to the events that occurred, and I asked you that very same question, and you only told me about A through E. You didn't tell me about F and G. So that's why it's very important that when you're asked, and typically that will be an open-ended question, when you're asked open-ended questions that start with, tell me everything you recall, tell me every way in which you were damaged, questions such as that, that you are accurate and as complete as possible. Oftentimes you'll be asked questions such as, what happened next? Is that everything that you can recall happening on that particular occasion? And so with respect to those questions, it's important that you're complete. Very often it makes sense to review documents, to review notes, and to discuss these issues with your attorney so that when you go into the deposition, your testimony on those questions are as complete and accurate as possible. To the extent that you go into deposition well prepared, and to the extent that you recognize that there are rules to be followed and you follow those rules, I'm sure you'll do quite well. Thank you.